Hello students, welcome to the lecture on Law of Contract, and after this lecture we will be able to learn the following objectives. Explain the nature of the contract. Describe the classification of contract. Explain the essential elements of a valid contract. Define the capacity of contracts. Discuss about termination of contract. Explain the breach of contract and its remedies. Define the term QUASI contracts. Let's start with a brief introduction to the law of contract. International contract law concerns the legal rules relating to cross-border agreements. When parties from different countries enter into a contract, they are governed by international contract law unless they agree to abide by the laws of one of the countries. It is frequently applied to international sales contracts. This type of contract law is broadly based on the idea of good faith and fair dealing in contracts. These principles are the basis of contract law in most jurisdictions. Good faith includes fair negotiations, an obligation to cooperate, and good faith when terminating a contract. It also ensures that unfair contracts or deals are not enforced. International contract law is a branch of private international law which relates to the cross-border dealings of individuals or companies. This differs from public international law, which concerns the interaction between governments and other state agencies. A contract is a legally enforceable agreement between two or more parties that create a legal obligation between them. The rules related to contracts can vary substantially between different types of legal systems.
A contract is a legal binding agreement among two or more parties that is enforceable by the courts. Each party involved in the contract must exchange considerations, which are promises of goods, funds, services, performance, non-performances, etc. A contract can be in written or non-written form. A contract that is made orally is called a parole contract. When a contract is breached, the damages depend on the terms of the contract. Damages are normally monetary, but can also be in the form of performance. Most contracts are enforced by state common law. This includes contracts for employment, real estate, insurance, business contracts, or intangible items. Different types of contracts. Contracts can be express contracts or implied contracts. An express contract is a contract where the elements such as the terms, offer, acceptance, and considerations are specifically stated, as opposed to an implied in fact contract where the elements are assumed. An implied in fact contract is a contract where an agreement between the two parties is assumed simply by the condition. Contracts can also be bilateral or unilateral. A bilateral contract is where both parties have mutually agreed to promise considerations. If Jim promises to cut Tom's yard for $50 and Tom promises to pay Jim $50, then they are both entered into a bilateral contract. A unilateral contract is when only one party makes a promise. An example would be if a radio station offered 2 game tickets to the first caller to answer a question correctly. There is no promise made by the person who wins the tickets. A contract that has been completely fulfilled is considered an executed contract, where a contract that has not yet been filled is called an executory contract. A formal contract is a contract that is legally binding due to the particular form or mode of expression. All other contracts are considered informal contracts. Contracts are governed by contract law, which is a subcategory of common law. Federal and state statutes or programs under statutory law may modify contract law entirely or in part. Although contract law is part of common law, the Uniform Commercial Code has almost completely replaced contract law regarding the sale of goods. The UCC is not law, but is recommendations made to state law. Article 2 of the UCC deals with the sale of goods. If a contract deals with the sale of goods, then one should refer to the UCC. If not, then the parties making the contract will refer to general contract laws as modified by statutory law.
Let us now discuss the nature of the contract. The law of contract is that branch of law which determines the circumstances in which promise made by the parties to a contract shall be legally binding on them. All of us enter into a number of contracts every day, knowingly or unknowingly. Each contract creates some right and duties upon the contracting parties. The basic natures of contract are difficulty of enforcement. Management contracts are essentially straightforward in their nature. They are contracts for the supply of personal services. A management contract will describe the services to be provided by the manager and will specify how he or she is to be paid for those services. Disguised management arrangements. For fear of being sacked and left only with the right to sue for damages, some managers try to protect their position by entering into alternative contractual arrangements with the artist. A de facto manager may prefer not to enter into a management agreement, but instead to require the artist to enter into recording and publishing agreements. The effect is that manager is exclusively entitled to the artist's songwriting and recording services and owns the copyright and all other rights in the artist's songs and recordings. Disguised management arrangements of this kind are properly treated with some skepticism, so that when an artist is presented with a contract by a manager, that contract will normally be a management contract rather than a recording and or publishing contract. This is not to say that production contracts, that is a recording contract entered into with small record production company, do not have a place in the music business. Joint venture. Nevertheless, there are circumstances in which a manager may be justified in seeking a greater degree of protection than is provided by a standard commission-based management contract. In fact, those circumstances now apply more frequently than before. As noted earlier, it is a trend for record companies to do less than in happier times and for management companies to fill the gap. If the management company assumes a significant overhead in terms of staff levels in order to provide a wider management service, and or if the manager makes a significant financial investment in the artist, for example by paying for recording and or video costs and or by providing tour support or general financial assistance, then the manager may be justified in seeking a greater level of protection. It may be that the level of the manager's investment and or the true nature of the manager's role justify an approach of this kind. An alternative, which is finding increasing favor, is for the manager to enter into a joint venture with the artist. A company or a limited liability partnership is usually incorporated to serve as the vehicle for any such joint venture. At the heart of this arrangement lies the fact that the company, and thus indirectly both parties to the joint venture, co-own any available rights. Now moving on to the next topic, we will study the classification of contract. Contract is an agreement enforceable by law between two or more parties for the doing or not doing of something specified. Contracts can also be classified according to performance. A contract can be either executed or executor. An executed contract is where one party has performed all that is required to be done according to the contract. Contracts can be classified into four broad divisions, namely the method of formation of a contract, the time of performance of contract, the parties of the contract, the method of formalities of the contract. The method of formation of a contract. Under the method of formation of a contract may be three kinds: express contract, implied contract, QUASI contract. Express contract. Express contract is one which expressed in words, spoken or written. When such a contract is formal, there is no difficulty in understanding the rights and obligations of the parties. Implied contract. The condition of an implied contract is to be understood from the acts, the contract of the parties, or the course of dealing between them. QUASI contract. There are certain dealings which are not contracts strictly, though the parties act as if there is a contract. The Contract Act specifies the various situations which come within what is called QUASI contract. The time of performance of contract. Under the method of the time of performance of contract may be two kinds: executed contract, executory contract. Executed contract, there are contracts where the parties perform their obligations immediately as soon as the contract is performed. Executory contract, in this contract, the obligations of the parties are to be performed at a later time. The parties of the contract. Under the method of the parties of the contract may be two kinds: bilateral contract, unilateral contract. Bilateral contract, there must be at last two parties to the contract. Therefore, all contracts are bilateral or multilateral. Unilateral contract. In certain contracts, one party has to fulfill his obligations, whereas the other party has already performed his obligations. Such a contract is called a unilateral contract. Let's now know the essential elements of a valid contract. We know that the two elements of a contract are an agreement, legal obligation. Section 10 of the Act provides for some more elements which are essential in order to constitute a valid contract. It reads as follows: all agreements are contract if they are made by free consent of parties competent to contract for a lawful consideration and with a lawful object, and are not hereby expressly declared to be void. Thus, the essential elements of a valid contract can be summed up as agreement, intention to create a legal relationship. Agreement. As already mentioned, to constitute a contract, there must be an agreement. An agreement is composed of two elements: offer and acceptance. The party making the offer is known as the offer, or the party to whom the offer is made is known as the offer. Thus, there are essentially to be two parties to an agreement. They both must be thinking of the same thing in the same sense. Intention to create legal relationship. As already mentioned, there should be an intention on the part of the parties to the agreement to create a legal relationship. An agreement of a purely social or domestic nature is not a contract. Capacity of contracts. The contracts that a business enters into with its customers and other individuals are important to its long-term growth and profitability. However, certain individuals lack the capacity or legal ability to enter into contracts. The law defines who these people are and prevents other individuals and businesses from having valid contracts with those who are said to lack capacity.
Hello Fiona, can I explain any legal concepts?
Professor Siegfried, what is a contract?
Well Fiona, a contract is a promise or a set of promises that is legally binding. In this context, a promise is an undertaking by one person to do something or refrain from doing something. If another person does something or refrains from doing something or makes a promise in return, a promise or set of promises will be legally binding if certain criteria are met. In Australia, this requires that there be an agreement, comprising an offer and acceptance, consideration, intention to create legal relations, compliance with any legal formalities, and that the parties have the legal capacity to contract.
Thanks, Professor, for defining a contract.
Certain class of people are exempted from the category of people who are capable of entering into contract: infants, minors, insane, mental incapacitation, minors. As a general rule, anyone under the age of 18 is said to lack capacity to enter into contracts. From a business standpoint, however, there are a number of important exceptions to the law prohibiting minors from having capacity. Mental incapacitation. Mental incapacitation is a legal term that refers to individuals who cannot enter into contracts because of psychological disabilities. In the majority of jurisdictions, mental capacity is defined as the ability to understand the full meaning and effects of the contract. Termination of contract. Once a party formally agrees to a contract, they become liable under law to fulfill their contractual duties. failure to perform the terms stated in the contract can result in a breach of contract, lawsuit, or other legal liabilities. Determine if one has any legal right to terminate the contract. There are limited circumstances which afford a party a right to terminate a contract. Such circumstances may include impossibility. If one party to a contract is unable to perform his or her obligations due to the impossibility of such performance, he or she may have a legal right to terminate the contract. Fraud. There are two kinds of fraud: constructive fraud and actual fraud. Constructive fraud occurs when a party unintentionally makes a false representation regarding a material matter of fact upon which the other party relies and as a result is injured. Breach of contract. Breach of contract is a legal term that describes a violation of a contract or agreement in which one party fails to fulfill its promises or by interfering with the ability of another party to fulfill its duties. A contract may be breached in whole or in part. Actual breach. It occurs where one party refuses to form his side of the bargain on due date or performs incompletely. For example, Pusud v. Spires and Bettany v. Guy. Effects of breach. A breach of contract, no matter what form it may take, always entitles the innocent party to maintain an action for damages, but the rule established by a long line of authorities is that the right of a party to treat a contract as discharged arises only in two situations. The breaches which give the innocent party the option of terminating the contract are renunciation. Renunciation occurs where a party refuses to perform his obligations under the contract. It may be either express or implied. Breach of condition. The second repudiatory breach occurs where the party in default has committed a breach of condition. Thus, for example, if Pusud v. Spires, the employer had a right to terminate the soprano's employment when she failed to arrive for performances.
X or intangible items. Insurance, business contract, real estate, insurance includes contracts for employment. This is state common law. Most contracts are enforced by performance, but can also be in the form of performally monetary. Damages are normal terms of the contract. The damages depend on the contract is breached. When a parole contract that is made orally is called a contract written or non-written form. A contract can be is assumed simply by the agreement between the two parties as a contract where an agreement fact contract and implied where the elements are assumed. Contract opposed to an implied and fact specifically stated as opposed and considerations are specific. Offer, acceptance, elements such as the terms is a contract where the element and express contract is contracts. Contracts or implied contracts can be expressed. Different types of contracts. Answer a question correctly. To the first caller to and offered 2 game tickets would be if a radio station. An example when only one party makes a promise. A bilateral contract is when a contract. A unilateral entered into a bilateral contract.
Remedies for breach of contract. Remedies for breach of contracts describes that in any situation in which there is a right, there is always a remedy, and a contract gives rise to correlative rights. An obligation remedy is the means given by the law for enforcement of a right. The 2 basic remedies for breach of contract include the money damages, restitution. A money damage award includes a sum of money that is given as compensation for financial losses caused by a breach of contract. Parties injured by a breach are entitled to the benefit of the bargain they entered or the net gain that would have accrued but for the breach. The type of breach governs the extent of damages that may be recovered. If the breach is a total breach, a plaintiff can recover damages in an amount equal to the sum or value the plaintiff would have received had the contract been fully performed by the defendant, including lost profits. However, if the cost of completion is prohibitive and the portion of the unperformed contract is small, many courts will only award damages in an amount equal to the difference between the diminished value of the contract as performed and the full value contemplated by the contract. For example, if the plaintiff agreed to pay the defendant 2 lakh to build a house, but the defendant only completed 90% of the work contemplated by the contract, a court might be inclined to award 20,000 in damages if it would cost the plaintiff twice as much to hire someone else to finish the last 10%. The same principle applies to damages sought for contracts that are fully performed but in a defective manner. If the defect is significant, the plaintiff can recover the cost of repair. But if the defect is minor, the plaintiff may be limited to recovering the difference between the values of the good or service actually received and the value of the good or service contemplated by the contract. A party is someone who has a legally binding obligation under a contract. It might be a seller obliged to deliver goods, a customer required to pay for them, a tenant required to pay rent, a landlord with an obligation to allow a business to operate from the landlord's warehouse, a bank obliged to lend money, or an account holder who must pay it back. Restitution is a remedy designed to restore the injured party to the position occupied prior to the formation of the contract. Parties seeking restitution may not request to be compensated for lost profits or other earnings caused by a breach. Instead, restitution aims at returning to the plaintiff any money or property given to the defendant under the contract. Plaintiffs typically seek restitution when contracts they have entered are voided by courts due to a defendant's incompetence or incapacity. The law allows incompetent and incapacitated persons to disavow their contractual duties, but generally only if the plaintiff is not made worse off by their disavowal. Remedies for breach of contracts include damages. Damages as one of the remedies for breach of contracts are monetary compensation allowed to the injured party of the loss for the injuries suffered by him or her as a result of the breach of contract. The fundamental principle is compensation and not punishment. The aim is to put the injured party in the same person he would have been had there been performance. As general rule, compensation must be commensurate with the injury or loss sustained arising naturally from the breach. If actual loss is not proved, no damages will be awarded. QUASI contracts. Most of us are familiar with the term contract, which refers to a legal agreement that binds the parties with duties and obligations. The contracting parties agree to the conditions of the contract either orally or in writing, and such contracts is enforceable in a court of law. In order to be classified as a valid contract, there must be an offer acceptance between the parties for a valid consideration. However, there is one type of contract wherein these factors are not needed for the formation of the contract. There is not contract between the parties till the court creates it. Connotative meaning. A QUASI contract is an obligation invoked by the law in the absence of an agreement. Its purpose is to create a legal duty where, in fact, no agreement was entered into by the parties. QUASI contracts are based on the principle of equity and justice. It simply states that nobody shall enrich himself unjustly at the expense of another. Now, in the end, let us summarize what we have learnt in this lecture. International contract law is a branch of private international law which relates to the cross-border dealings of individuals or companies. A contract is a legally enforceable agreement between two or more parties that creates a legal obligation between them. An executed contract is where one party has performed all that is required to be done according to the contract. A voidable contract is an agreement which is enforceable by law at the option of one or more of the parties thereto, but not at the option of other or others. Contract is an agreement enforceable by law between two or more parties for the doing or not doing of something specified.